Hello aspirants, welcome back to Where I Is. So in our discussion on Indian polity, we were studying about fundamental rights. So in the topic of fundamental rights, I said that there are 6 topics that is to be covered. And we had already covered these 5 topics in detail, and we had started with the 6th topic, that is the classification of fundamental rights. So in classification of fundamental rights, we studied that there are 6 fundamental rights, and we had also covered all these 5 fundamental rights, that is right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights in detail in our previous video lectures. And we had started with right to constitutional remedies. That is, we studied about the basic introduction for this right to constitutional remedies. Now we shall study this right to constitutional remedies in detail, that is, which is given under Article 32. We shall study about this in detail now. That is right to constitutional remedies, which is under Article 32. To revise this right to constitutional remedies, which is given under Article 32, that is, if there is a threat or the violation for the fundamental rights, we can seek the remedies or the solutions, and this solutions or the remedies is given in the form of writs. That is what is Article 32 is speaking about. That is, if there is a violation of fundamental rights, so there has to be some protection, right? There has to be some solution or the remedies, correct? So this solutions or remedies itself is made as a fundamental right. That is the beauty of fundamental right or the significance of fundamental right. The protection for the violation of fundamental right is itself a fundamental right under Article 32 of our Constitution. And this, for the violation of fundamental right, there is a protection or the remedy issued in the form of writs. That is what is Article 32 is speaking about. And the protection for the violation of fundamental right is itself a fundamental right under Article 32. And this is the significance of fundamental right. And for this reason, Article 32 is called as heart and soul of the Constitution by Dr. B.R. Ambedkar. So where can we seek the remedies then? Where to seek the solutions for the violation of fundamental rights? That is, we can directly go to Supreme Court. That is what is Article 32 is telling about. Then what about the case of other courts? Yes, other courts can also issue the writs for the violation of fundamental rights, but the Parliament has to empower that court to issue the writs. That is what is Article 32 is speaking about. That is, for now only the Supreme Court has been given the powers to issue the writs for the violation of fundamental rights, whereas the other courts, for the other courts to issue the writs, the Parliament has to empower that particular court to issue the writs. And also, what is the meaning of writs then? That is, Supreme Court can issue the writs, right? So the meaning of writs is nothing but it's a written court order, and the concept of writ, this writ was taken from Britain Constitution, and the writ jurisdiction of Supreme Court is original because we can directly go to Supreme Court. Hence this writ jurisdiction of Supreme Court is called as original. But this writ jurisdiction of Supreme Court is not exclusive because even High Court has got the power to issue writs. Then what is the difference between the writ jurisdiction of Supreme Court and High Court is to be understood. The writ jurisdiction of Supreme Court, I said, it is covered under Article 32 of our Constitution, whereas the writ jurisdiction of High Court is covered under Article 226 of our Constitution. And so Supreme Court can issue the writs for the violation of fundamental rights only, whereas the High Court can issue writs for the violation of all legal rights. So what is the meaning of legal rights then? See, this legal rights is nothing but those rights which have the backing of law, and this legal right, it covers the vast list of rights. That is, it covers the constitutional rights as well as the statutory rights. That is, take for example right to information. This right to information, it is still a right, correct, but this right to information is not having any position in the Constitution, but this right to information is having a backing of a statute, that is law, called as Right to Information Act. So this right also has to be protected, correct? So this protection for the other statutory rights, this is given to High Court. That is, High Court can issue writs for the violation of all legal rights, and this legal rights covers both the constitutional and the statutory rights. In constitutional rights, we know that is those rights which are covered under the Part 3 of Constitution are called as fundamental rights, and those rights which are outside the Part 3 of Constitution or other constitutional rights. So the entire list of rights, for the entire list of legal rights, the protection is given to High Court. And also here, when we go to Supreme Court to seek the remedy for the protection of fundamental rights, Supreme Court is bound to accept that case, because Supreme Court is considered as the custodian or the guardian for the protection of fundamental rights, whereas High Court may or may not accept the case. So that is the difference between the writ jurisdiction of Supreme Court and High Court. To revise, it is nothing but Supreme Court can issue writs only for the violation of fundamental rights, and Supreme Court is bound to accept the case because Supreme Court is the custodian or the guardian of fundamental rights, whereas High Courts can issue writs for the violation of all legal rights, and High Court may or may not accept the case. So that is the difference between the writ jurisdiction of Supreme Court and High Court. So what are the types of writs we have then? So we have 5 types of writs. The first is habeas corpus, second is mandamus, third is certiorari, fourth is prohibition, and the fifth writ is quo warranto. What is the meaning of each writ? So that is to be studied now. So the meaning of each writ, that is the habeas corpus. The first writ we have is habeas corpus. Habeas corpus literally means to have body. That is, take for example, in the missing cases, we can go and seek the remedy in the form of habeas corpus. So if the court is issuing the habeas corpus, that means the person has to be produced before the court. That is, the missing person has to be produced before the court in the missing cases, even with respect to the arrest. So if there is a person who is arrested, even in that case also, to check the legality of that detention or arrest, even in that cases also habeas corpus can be issued. And also here it is to be noted that if there is a case of preventive detention, so the motive of preventive detention is completely different, correct? Because preventive detention is used when to prevent the person from committing the crime in future, correct? So this preventive detention concept is completely different. We had already covered this preventive detention in our previous video lectures. So here this habeas corpus is issued in missing cases and also to check the legality of detention, but it is not issued with respect to the preventive detention cases. Arrest under the preventive detention, for that habeas corpus cannot be used. And also in habeas corpus, the locus standi is not applicable. So what is the meaning of locus standi is? Locus standi is nothing but the stand or the position of a person with respect to the case. That is, whether that person is a victim or accused or witness. That is the meaning of locus standi. That is, what is the hold or the position of that person with respect to the case is the meaning of locus standi. And in habeas corpus cases, the locus standi is not applicable. That is, any aggrieved person can file the case of habeas corpus. So this is about habeas corpus. So the next writ we have is mandamus. Mandamus means we command. That is, we command to take action. That is, take for example, if you go to the police station and you want to file a case, and if that police officer is refusing to file a case, then you can go ask the court or a senior official. Then the court can issue the mandamus. That is the command order to take action. That is, the police officer has to take action, right? So for that the writ of mandamus can be issued. And here the locus standi is applicable with respect to the writ of mandamus. That is, only the person who is related to the case can only file the writ of mandamus. The next writ we have is certiorari. Certiorari is curative. That is, take for example, High Court has issued an order, and this order, if it is exceeding the jurisdiction of High Court or if it is beyond the constitutional limits, then we can go appeal to the Supreme Court, and the Supreme Court can cancel whatever the order that High Court has issued. So it is a cure that Supreme Court is giving for the judgment against the High Court, correct? So this hence this certiorari is called as curative. And here the locus standi is applicable even with respect to the certiorari. That is, only the person who is related to that particular case can only seek the remedies under certiorari. Next writ we have is prohibition. So here in prohibition, the meaning is to stop. That is, the case will be still in the trial stage in High Court. That is, the High Court will might have not issued the final judgment. So in this type of cases, the Supreme Court can ask the High Court to stop from the further proceedings, because the Supreme Court may feel that the High Court is exceeding its jurisdiction. So in this case, the Supreme Court beforehand, that is before the High Court comes up with the final judgment, before that itself the Supreme Court may ask the High Court to stop from further proceedings. So this is the kind of preventive measure that Supreme Court is taking, correct? So hence this prohibition is called as preventive in nature. That is, before the final judgment itself, Supreme Court asks the High Court to stop from the further proceedings. So hence this prohibition is the preventive in nature. Whereas here also the locus standi is applicable. That is, only the person who is related to the case only can seek the remedies under prohibition. The next and also here the prohibition and certiorari writs can be issued only with respect to the judicial and quasi-judicial bodies. Next we have is last writ, that is quo warranto. Quo warranto means with what authority a person is holding a public office. To check this, then the quo warranto writ can be issued. So here once again the locus standi is not applicable. That is, any aggrieved person can seek the remedy of writ to know with what authority, with what powers that person is holding a public office or the government office, to check that the quo warranto writ can be issued. So to revise these types of writs, I said that in the cases of habeas corpus and quo warranto, the locus standi is not applicable. That is, any person can seek the, any aggrieved person can seek the remedies of habeas corpus and quo warranto. Whereas the mandamus, certiorari and prohibition, in these cases, the locus standi is applicable. That is, the person who is related to the case can only seek the remedies of mandamus, certiorari or prohibition. And mandamus, to understand the meaning of habeas corpus is used when there is a person missing. So when to check the legality of the arrest, this habeas corpus can be used. Whereas mandamus, it is like a command. It is like a command for the official to take action. So that is when the mandamus is issued. Whereas certiorari and prohibition, we had studied, correct? Because this certiorari is with respect to the, it's like a cure. If there is a judgment that is passed, to cancel that judgment, this certiorari writ can be used. That is, it is like a cure that the Supreme Court is providing for. Whereas this prohibition is preventive. That is, to prevent the High Court from exceeding the jurisdiction, Supreme Court beforehand itself asks the High Court to stop it from the further proceedings. Hence this prohibition is preventive, whereas certiorari is curative, and this both prohibition and certiorari is used for the judicial and quasi-judicial bodies. And this quo warranto, that is to check with what authority that person is holding the public office. To check that, we can use the writ of quo warranto. And this completes Article 32 of our Constitution. That is, the right to constitutional remedies is completed. For further videos, keep watching VRIS, and also please share, subscribe VRIS. Thank you.